Thank you, Mr. Chairman, and thank you to all of you for being here today as we work to identify solutions and improvements to this process. For us to have a panel such as this is extremely helpful. So we are very grateful to have your years of experience and your background working in this subject matter here with us today, both your written testimony and what you've shared with us during this hearing. We have a number of us commented, and I think it bears noting again here today, the good work and integrity of so many of the men and women of the FBI who work out in field offices across this country. However, that said, we are of course here to address a very specific and serious concern, which is the misuse of FISA and surveillance techniques, and I believe there's broad agreement here that we have much needed reforms to discuss. I'd like to go back, Mr. Scher, to some of what you've testified about in parts of your written testimony that you submitted to us. So we know that 702 is providing the FBI with access to a large amount of information about Americans. But one thing that you have touched on, when we look at the concept of potentially creating alternative statutory schemes or potential revision, the concept that the government is also utilizing other sources of information, private data, other things to essentially surveil or gather information about Americans. I'd like to hear more about that subject and what you would propose, if anything, we should be doing to try to monitor or curtail that practice.
I assume that you're referring to the purchase of data,
yes,
which is, in my view, an equally, if not more serious problem than the vast trove of information that's collected under pursuant to Section 702. And certainly both of those enormous databases together can be an enormously powerful surveillance tool. And like any other surveillance tool, it should be subject, in my view, to a judicial order with a probable cause requirement. I think that's the most important thing that can be done. I don't think any of us here on the panel are disputing the wisdom or the ability of the FBI to collect the underlying data. Yes, in many instances it's broader than it needs to be, but the key event is not so much the collection of the data as the searching of that data using identifiers that are specific to American citizens. In my view, that constitutes a search for Fourth Amendment purposes, and even if you disagree with that, it's still an important event to the privacy of an American citizen, and is therefore something that Congress can and should regulate very closely.
Okay. Thank you, Mr. Scher. Professor Turley, I'd like to go back to something you mentioned earlier as well, and that is the concept of making the FISC court process more adversarial, adding an adversarial component of that or having an amicus involved in that process. Would you elaborate for us on how you think that type of reform could be implemented and how that might look?
Thank you very much for that question. The Congress years ago implemented this amicus process by which the court can reach out by what the Congress described as novel questions to get the assistance of essentially a third-party view separate from the government. That has been relatively underutilized. And as far as I know, there's no indication it's ever been used in an individual case where the FISC court says, can you look at this application? And what we know is that when we actually put those applications under a spotlight, which is relatively rare, as the chair mentioned, out of, I think, 29 cases reviewed, 25 of them were in error. So there's obviously a need for some additional viewpoint. I don't think that's going to be achieved with any amicus curiae. I think that what you really need is this sort of concept of a special advocate, a formal office that has the ability, among other things, to bring a case to the appellate FISA court, to say that there's a problem here that you should reveal or review. I think that would be very useful to have an actual privacy advocate with security advocacy. If you're going to have a secret court, let's make sure both are represented.
Thank you, Professor Turley. And Mr. Chairman, I yield back.
Thank you. Chair recognizes